The following excerpt is taken from the ABCs of the UCC, Amended Article 2A, Leases by Amelia H. Boss and Stephen T. Whalen. Copyright 2005 by the American Bar Association. Reprinted here with permission. The material contained herein represents the opinions of the authors and editors and should not be construed to be the action of either the American Bar Association or the section of business law unless adopted pursuant to the bylaws of the association. Nothing contained herein is to be considered as the rendering of legal advice for specific cases, and readers are responsible for obtaining such advice from their own legal counsel. To request reprint permission, contact the manager, Copyrights and Licensing, at 312-988-6102. Introduction. A. History of Article 2A. Examples of leasing transactions can be traced back to Roman times, but it has only been within recent years, since the original enactment of the Uniform Commercial Code, that leasing as an industry has grown and flourished. Fed by such benefits as favorable tax and accounting treatment, leasing began to grow tremendously during the 1950s and 1960s, soon coming into its own as a distinct industry. Despite its ancient origins, the law applicable to leasing transactions was far from clear. Efforts were made to draw principles from the ancient law of bailments. Sales law was often used by analogy, and the law of conditional sales, secured transactions, licensing, and real estate leasing law were frequently invoked. The uncertain nature of the law of leasing led, in the early 1980s, to efforts to codify the law of leasing. Although originally proposed and formulated as a freestanding, independent, and uniform law, when this new codification finally emerged in 1987, it was presented as the first new addition to the Uniform Commercial Code, Article 2A on leases. The choice of the article number was a reflection of the fact that this new body of leasing law was based primarily on the sales law found in Article 2 of the Code. Oklahoma, in 1988, was the first state to enact Article 2A, followed by South Dakota, California, and several other states. From the very beginning, however, Article 2A was subjected to non-uniform amendments which undercut its status as a uniform law. Academic critique began, and several states, including New York and California, raised serious questions about specific provisions of Article 2A. As a result of these criticisms, questions, and other input, official amendments to Article 2A were proposed and adopted in 1990, leading to the 1990 official text. Subsequently, however, efforts began to revise both the sales and leasing articles of the Code. These culminated in 2003 with the final adoption of the 2003 amendments to Articles 2 and 2A. The amendments were much more limited in scope than had been originally anticipated when the revision process began. The focus of this revision attempt was primarily on the sales provisions of the Code. 1. To the ABCs of the UCC, amended Article 2A, Leases, and Article 2A was amended only to conform, in most situations, to the limited revisions to Article 2. As of this writing, 2004 amended Article 2A has not been adopted in any state. As a result, this book will discuss primarily the 1990 official text and, where appropriate, the 2003 amendments as well. Citations are to the 2003 official text, and, where different, references to the 1990 official text or its language appear in brackets. Additionally, Article 1 was revised and renumbered in 2001. All citations to Article 1 that follow are to the 2001 revisions with the pre-revision citation following in brackets. B. Basic Principles and Interpretation of Article 2A. One of the basic tenets on which the entire Uniform Commercial Code is based is the notion that the parties to a transaction should be able to agree to the rules applicable to them, and set forth those terms under which they intend to do business. Section 1 to 302, Section 1 to 102, 3. This concept of freedom of contract runs throughout Article 2A. Section 2A 101, Official Comment. The latitude extended to lessors and lessees includes the ability to contractually alter the obligations imposed on them by Article 2A. The only limitation is that the obligations of good faith, diligence, reasonableness, and care imposed by the Code may not be disclaimed, although the parties may set forth the standards by which such obligations are to be measured. Section 1 to 302b, Section 1 to 102(3). Thus, in many fully negotiated lease deals, Article 2A will function as a backdrop against which the terms of the transaction are negotiated. In non-negotiated deals, or where the agreement entered into by the parties is found unenforceable, the Code provides a comprehensive set of rules governing the transaction and providing its terms. There are, of course, limitations on the parties' ability to agree. For example, in Donka Funding Company vs. Sky City Casino, 747A.2d 837 NJ. Super. Court Law Div. 1999, the court upheld an Indian tribe's sovereign immunity from civil suit despite the existence of a forum selection clause in an equipment lease. Furthermore, as discussed below, a court has the ability to refuse to enforce the lease agreement, or any part of it, should it find the agreement or its terms to be unconscionable. Section 2A1081. The obligation of good faith in the performance or enforcement of any lease contract is likewise imposed by the Code in Article 2A and is not disclaimable. Sections 2A103 1M 1 to 304, 1 to 302b, Sections 1 to 203, 1 to 102(3). Moreover, as will be discussed below, in the case of consumer leases, the consumer receives special protection that may override the terms of the lease agreement. Article 2A is, nonetheless, based on a model of freedom of contract, and contains relatively few mandatory provisions. There is no general requirement that a lessor file a financing statement or similar document to protect its interest in the leased goods. Nonetheless, lessors should proceed cautiously. First, prudent lessors will continue to file protective financing statements under Section 9 to 505, thereby guarding against the possibility that the lease will be found, not to create a lease, but to create a security interest under Sections 1 to 201(35) and 1 to 203, Section 1201(37), potentially leading to the defeat of the lessor's interest under the rules found in Article 9. Second, where the lessor anticipates that the leased goods will become attached to real estate, the lessor should make a fixture filing. Section 2A309. Copyright 2005 by the American Bar Association. The ABCs of the UCC, amended Article 2A, Leases 3. Last, certificate of title statutes in many jurisdictions may require that lessors note their interest in such items as automobiles, trailers, mobile homes, boats, and farm tractors on the certificate of title covering the leased item in order to assert those interests against third parties. Section 2A104. Leasing law found in Article 2A continues to be supplemented by other law, such as the law of estoppel, fraud, and mistake. Section 1 to 103b, Section 1 to 103. In addition, an applicable rule of law that establishes a different rule for consumers will continue to apply and will not be preempted by Article 2A's provisions. Section 2A104. Thus, in B&S Marketing Enterprises, LLC v. Consumer Protection Division, 153 MD App. 130, 835A.2d 215 MD Court Spec. App. 2003, the court applied Maryland consumer loan law rather than the UCC in determining whether a purported sale-leaseback was in reality a loan which violated usury laws. Similarly, in LaChapelle v. Toyota Motor Credit Corp. 102 Cal. App.4th 977, 126 Cal. RPTR.2d 32 Cal. Court App. 2002, a controversy involving whether truth in lending wording was required in the contract, the court noted that although it concluded that the outcome of the case would be the same under California's Article 2A or under California's Vehicle Leasing Act or Consumer Legal Remedies Act, in the event of a conflict, Article 2A would give way to the consumer law. As Article 2A is a relatively recent addition to the Uniform Commercial Code, courts will undoubtedly be called upon to interpret its provisions in cases of first impression. These courts will not, however, be writing on a completely clean slate. To the extent that Article 2A's provisions are based upon comparable provisions of Article 2 on sales, with only minor changes to reflect changes in leasing terminology, decisions under Article 2 should be viewed as persuasive but not binding, in determining the meaning of parallel Article 2A provisions. Section 2A 101, Official Comment. Similarly, the official comments to the sales provisions may be of guidance in interpreting the parallel leasing provisions. In instances where the leasing provision is drawn from Article 9 on secured transactions, as is the case with respect to the right to repossession, it is reasonable to expect that the decisions under the Article 9 counterpart section on such issues as what constitutes breach of the peace will be relevant. Care should be taken, however, to distinguish those situations where the drafters of Article 2A affirmatively rejected Article 2's provisions as a model. Where legitimate differences between the articles exist, blind adherence to parallelism would be unwarranted. As the official comments to the 2003 amendments remind us, leasing is distinctive. Copyright 2005 by the American Bar Association.